This is your first time of passing by or watching our episode. Thank you very much for coming. Thank you very much for watching. Thank you very much for your support. And if you have watched before, thank you very much too. Now, land. Everybody needs land. Everybody wants land. Everybody wants to build a house, comfortable place. But in most of the courts in Nigeria, land cases account for majority of the litigation there. So one person buys land, somebody will encroach, he will take the person to court. So all these land disputes and land cases are there. Now we want to look at how can you prove your ownership of land in Nigeria. 5 ways that you can prove your ownership of land in Nigeria. Anytime there's some challenge, 5 ways you can do so. And even if there's been no challenge, you should know, so that you know how to protect yourself, to protect your land in case of any future problem. I hope there will be no problem, but some people would always bring problem for land that does not belong to them. So how do you fortify yourself? So we're looking at the 5 ways that you can prove your ownership of land in Nigeria. Now, there are 5 ways that have been established by the courts. The first way to prove your ownership of the land, to prove that you own the land, is true evidence of traditional history. True evidence of traditional history. Now, this evidence of traditional history means that you can give oral evidence of how maybe your ancestors settled on the land, how your forefather, your grandfather, your great-grandfather, your great-great-great-grandfather deforested the land, how long they occupied it for, and from them who inherited it and who also inherited it, and how did it get to either you or your present generation or the people who are there now. So this can apply to one parcel of land to several hundred parcels or acres or hectares of land, even villages and towns. To establish who are the real owners, you can use traditional history. Okay, so evidence of traditional history. You must be able to recount the history of the place. How these people were the original settlers, how this other group came as either workers, and they were just given a place to stay as tenants, traditional tenants, and they were paying some homage or they were paying rent or royalties to the real owners. All of that history, obviously there will be conflict in history. This group will have their own history, the other group will have their own history, but at the end, whoever is adjudicating on the matter, the court or the judge or whoever, will be able to look at it and decide, okay, I believe these people more because their own makes more sense, and there's an unbroken chain of possession of the history is properly established. So that is number 1 way to prove ownership of land, true evidence of traditional history. So if you are in land and there is some doubt, some dispute as to who are the original owners, who are the original settlers, who are the people that deforested it, you probably want to relate with your elderly people, with your elders, with the old men and old women, with the chiefs, and then ask them to give a proper account of the history of that village or of that land, because one day it might become important. And don't forget that land litigation sometimes can last for several years. On the other hand, at some point there may have been some problems or dispossession of land by one group and another, But eventually it will get to court, and if it gets to court, this evidence of traditional history will become, quite important. So, number one way, evidence of traditional history. All right, that's number one. Then number two way to prove, or establish title to land is through production of documents of title which are duly authenticated. So you talk about documents of title which are duly authenticated. The first document of title will be the one issued by the original owners of the land. So if there was a contention as to who is the, between Mr. A and Mr. B, who is the owner of the land, the claimant or the plaintiff or the person who went to court or the person who is asserting, who is saying, look, I own the land, should be able to produce a document by which he acquired the land from the original owners, either by purchase, either it was a pledge, a pawn, a sale or purchase, or a gift. Land can be, ownership of land can transfer through a gift. In law, we call it a gift inter vivos. That's a gift of land, while one is alive. Or even by will. If a land is willed, a parcel of land is willed to somebody, a testator, somebody called a testator, in making a will, gifts or bequeaths, the ownership of land to somebody, that is a document of title. Okay, so once the will is proved, it's admitted to probate, that's a document of title. So this is one second way, by producing documents of title. Documents of title refers to things like deeds of conveyance. Deeds of conveyance, a document of title. If you are living in the Benin area before 1978, the Oba's approval was a preeminent document of title. Before 1978, the Oba of Benin was the person who had the powers, preeminently to allocate land to people. So once you had the Oba's approval, that confirmed that you were the owner of the land. The Oba's approval was just an application that anyone could make for land through a plot allotment committee. It goes to the Oba, and the Oba will just write approved, sign it, and date it. So that document carrying the Oba's signature was called the Oba's approval. So before 1978, that document was sufficient to confer ownership on you relating to land anywhere within or outside Benin City. Okay, but that was before 1978. So after 1978, when the Land Use Act came into effect, the Oba of Benin, with all due respect, lost his power, his traditional power or right to give approval, for ownership of lands in Benin Kingdom. So what is applicable now is, the traditional land tenure system, was revived. So you still have to go, of course, as of today, all lands have owners. I don't think there's any land that is actually what in law we call bona vacantia, a vacant piece of land without an owner. I don't know if there's any community. If there is in your community, let us know in the comment section whether there's a large parcel of land that is ownerless. So every land has an owner now. So if you want to acquire land, you need to go to the owner, and it is that document it gives you, either by deed of conveyance or or whatever, by will or whatever. That effectively can convey ownership to you. Now, another thing that you want to probably know is that if you have a deed of conveyance from the owner, then you can go to the governor to give you a certificate of occupancy, with which, if you want to, you can purchase, you can get a loan from a bank. But in another video, and that's not the subject of this video, but you can watch the video where we talked about that a certificate of ownership does not give you title to land. You can watch that video, scroll through our videos, and then you can watch that for to get the information. But I'll just say here that having the certificate of occupancy from the governor without having purchased the land from the people who are the owner, or from the person who is the owner, does not give you anything. So if you have your certificate of occupancy from the governor, you must also have, the deed of conveyance from the owner of the land. A question has also been asked as to the status of survey plan made by surveyors. Well, the purpose of a survey plan is not to confer or change or extinguish or establish title to land. A survey plan does not establish title. A survey plan is not a title document of land. It is only a document showing either measurement or dimensions of a particular parcel of land. That's all. That's all. So it doesn't change title, it doesn't give title, it doesn't establish title, it doesn't extinguish title, it doesn't transmit title. A surveyor cannot give you title. A surveyor is just a professional that you can meet and say, okay, I've got this parcel of land, please come and help me measure it. And when it is measured, he can take it and register. He can register that survey plan with the Ministry of Lands. But the registration does not give anything. It just shows the dimension of the land that is surveyed. If the person who surveyed that land is not the original owner, he still will not get anything. You see? He won't get anything. So I'm talking about the second way to prove your title to land, through production of documents of title which are duly authenticated. Duly authenticated. So if you are in Abuja, you need to find out, how to get land from the original indigenes of that land. Merely getting a certificate from the Abuja Municipal Authority is not sufficient. It's not sufficient. Now, I need to address this point, because in some states, the governor will acquire in a vast area of land and say it's for public purpose. They want to build housing estates. And then the government will now go into private arrangement with private company to become builders. Then they will now sell the buildings to people at a profit. And the government will take some part of the money. And then the private developer will take some part of the money. Now, that one is illegal. That's illegal. Government cannot acquire land except strictly for public purposes. Only for public purposes. Once there is private interest in it, that acquisition becomes null and void. And when government acquires land, you can only use it for the purpose that you stated when you were acquiring it. You can't change it. Okay? So, now I'm not knocking any government. Don't say, oh, Dele Igbenedion is knocking, any government. No. I'm not knocking any government. But the point is that by our law, and I've got a law here. That's the Land Use Act. By the Land Use Act, the governor can only acquire land for government use only, for public purpose. You acquire, you need to pay compensation, and even the process of acquisition has its own formality. Number one, you must identify the people who are there. You must serve them notice. You must enumerate, developments on the land, and you must pay them compensation. After which you must revoke their rights. You must first revoke their rights before you acquire. If you acquire without revoking their rights, it's a no. It's a no-show. So that will be wrong. If you acquire private land and for public purpose, and then as a governor, you now give that same land to another private company to use, it's a no. That again, it's a no. So just be wary of this one. So I only said that to say that a certificate of occupancy issued by the governor does not give title. It's not a title document. It is only a certification that you are in possession of the land. You, the bearer of the certificate. So if you are not in possession, if you have not acquired possession validly, but you just short circuit the process, you bypass the process, you take a shortcut because you have political connections, you just meet the governor, they give you a certificate of occupancy, my brother, my sister, you would have obtained nothing. Okay, so that's the second way. We've said the first way is through evidence of traditional history. We say the second one is through production of document of title which are duly authenticated. So duly authenticated means signed by the real people, the correct people. Okay, so if you have a document of title not signed by the correct people, it cannot give you title. Title does not move except from the owner to you. And there are people who owns the land, even in Nigeria today. Okay, the principle of law is nemo det quod non habet. Nemo det quod non habet. But somebody can only give you what he has. A person cannot give you what he does not have. So if you want to acquire ownership of land, you must go to the owner. It is the owner that cannot give you ownership. If you go to somebody else who is not the owner, that person cannot give you what he does not have. He can only give you what he has. And if what he has is not ownership, then you have actually obtained nothing. All right. Well, I hope you find this interesting. I don't know how many minutes we have done. We just do a short break and then we will be right back. But if you are enjoying this, please do subscribe to Pinnacle TV YouTube channel. All you need to do to subscribe is just to click the letters there, subscribe in capital letter. Just click on it. A bell will show up. You click on the bell. That's called the notification bell, so that anytime I post videos on law, you automatically get it immediately, so you can decide whether you want to watch or whether you do not want to watch. Okay, but I think you would like to watch because these are interesting videos. Then also give us a thumbs up if you are enjoying this program, or if you are not, give us a thumbs down. But communicate, show some activity so that we know that you actually pass by. If you have comments, please leave comments in the comment section. We always read the comments and we will always respond, to the comment. The producers of the show will respond, to the comments. The phone number is there if you want to, talk to somebody, and the producers will talk to you. Finally, to always share our videos. All right, so I'll take a short break and then I will be right back. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. So we're looking at 5 ways to prove that you are the owner of land in Nigeria. The first one we have talked about is through evidence of traditional history. Second one, through documents of title. And we have said documents of title duly authenticated. So you need to get documents from the real owners of the land. Don't rely on youths, because youths actually don't own land. So don't rely on youths because they have some guns and they are drinking alcohol and smoking, some narcotic. And then you think, okay, yes, they are the owners of the land. Don't give them money. Ask them, where are the real owners of the land? Because those are the ones that can actually convey title to you. Don't forget, land is a resource that never diminishes. So if you purchase land from the wrong person, you will never get title. And title that you never had, it never becomes, in other words, non-ownership can never ripen into ownership. Long possession does not make you the owner if you never had, original title. Okay, so that's the important thing. You need to buy from the right person so that you don't waste your money. We've also said that when we talk about title document, that certificate of occupancy is not a document of title of ownership. It is a document showing that you are entitled to possess the land, to occupy the land. It doesn't give you title document. So that's the two. The number 3, now we come to the number 3 way to prove that you are the owner of the land. The number 3 way is by acts of ownership. By acts of ownership extending over a sufficient length of time, numerous and positive enough to warrant the inference that the person is the true owner. In other words, acts of ownership, acts over the land showing that you are the owner over a long period of time, numerous and positive enough to warrant the inference that you are the owner. You know, really and truly, if you are the owner of land, there are things that you do there now to show that you are the owner of the land. Maybe you farm on it, maybe you rent it out, maybe you once in a while you come and harvest some bananas and all those things on the land. Maybe church wants to do a crusade there. You are the person they come to. You issue them a receipt. They pay you money, you know, and things like that. So people want to use that land. You are the person they come to. Government wants to use it for immunization or whatever, or they come to you. So such acts of ownership, you know, you farm on it over a long, sufficient length of time, which are numerous, not just one. There should be numerous acts of land that you own. There are normal things, natural things you do on the land as the owner now to show that you are the owner of the land. Okay, you may not do them to show people I'm the owner of the land, but normal things you do as the owner of a land. You go there and harvest the palm, the fruits on the land. You go there and set trap. You know, you build a kiosk there. All those things show that you are the owner of the land. So that is, even though you may not have documents of title, you know, you may have inherited it and you don't have a document, but through this, your acts of ownership over a period of time, sufficient, numerous enough, you know, to lead the inference that you are the owner. So when there's a discussion as to who owns that land in by the junction, say, it belongs to Mr. Igbinedion, you know. Don't you see that that mechanic there is the one that put him there now? He's the one that is collecting rent. Is the one, okay. And when the government was building now, when the government was constructing that road, he's the one the government went to they now pay the compensation for that part. So all those are actions that are indicative of you as the owner, really and truly. If you are collecting compensation over a part of land, and somebody else says the owner, and he folds his hand and watches you collect compensation over his land, then how will he prove that he is the owner of the land? So that's the third one, acts of ownership, your acts of ownership over the land. So if you own land, periodically, you must go and show that you are the owner of the land. Don't just leave it there. Periodically show acts of ownership. If somebody wants to use it, you know, to do some, ask him, okay, yes, I'm the owner. Okay, you want to use it for how long? Say, okay, I'll use it for every year. Okay, how much will you be paying? I'll be paying you 5,000 naira, sir. Okay, you issue a receipt and you keep a copy. Make him sign. So all those ones over a period of time are able to, the court can put it together to draw the inference that, you know, you are the true owner. Number 4 way to prove that you are the owner of land is through acts of long possession and enjoyment of the land. Okay, this one does not require document. You may not have document, but over time you have been farming on it. You have been you have built on it. You built on it. You have been living there without challenge over a long period of time, and the person challenging you now has been seeing you there. They have been seeing you there. He cannot come up later to begin to challenge you, because in law we have a principle that we call the doctrine of standing by. Doctrine of standing by. If someone is building on your land and you watch him building, you watch him open the house, he does an opening ceremony, you are watching him, he packs in, you are watching him, he's living there, you know, and obviously you have agreed that he's the owner of the land. The law says you are standing. Maybe even he went to court with somebody on that land. There was a quarrel. They went to the palace of the Baale or the Odionwere or the Emir, and there was traditional arbitration. And between him and that person, the Emir decided, based on the evidence, that he is the owner of the land. And you were aware. You folded your hands. You did nothing. So that in law is called standing by. Then we also have a principle we call leches and acquiescence. Don't forget, and it's important that I should chip this in for free. If you have a dispute over land, you are expected by law to go to court to litigate your grievance within a period of 10 or 12 years, depending on the state. Some states have their own, what they call the limitation law, which is for 10 years. Other states have it for 12 years. So you need to find out the state that you are, whether it's 10 or 12 years. So from the time that your title is challenged, your ownership title is challenged, you have 10 or 12 years to litigate, to go to court. After that period, you cannot use the court anymore. So, in other words, you lose your right to your land. Okay? So, but your time starts to count from when your title is challenged. And if your title is not challenged, no problem. But from when your title is challenged, you have to, file your suit in court, either 10 or 12 years. All right? So number 4 we're looking at is through acts of long possession and enjoyment of the land. So if you have been possessing and enjoying land over a long period of time, particularly up to at least 10 or 12 years, you automatically become the owner of the land. Nobody else can come and challenge you again over that land. Okay, so that's why in law we say if you are in possession of land for 10 years plus 1 day, or 12 years plus 1 day, depending on the state where you are, you automatically become the owner of the land. Now, this is something that you also need to watch out, for people who are on your land and they are contending against you. Don't say, well, I'm leaving them, I'm watching them, I'm leaving them, I'm watching them. You have a limited period by which you must go to court. So you need to check now. If you have such a situation, check now, to be sure that, the 10 years or the 12 years, depending on the state that you are, doesn't, count or run against you. Okay, we call that limitation law. After that 10 or 12 year period, then you cannot litigate again in court. You can't take the matter to court. You just have to, you have to leave it like that. Okay, so that's number 4 way. And the last one, number 5 way to prove you are the owner of land is by proof of possession of connected or adjacent land in circumstances rendering it probable that the owner of such connected or adjacent land would, in addition, be the owner of the land in dispute. For example, if there's a dispute as to, who owns this land, and you can prove that, even the one next to it, I'm also the owner, and I bought all of them together from the same person. I haven't bought all of them from the same person. I just cut this one and I'm using this one. I left this one hoping that in future I can build on it. So the law will look at connected land to that or adjacent land to it to decide, okay, from your story now, well, it makes sense that, you are the owner of this land. If you own the one next door, most chances are you own the other one. If you, depending on your evidence, it's not automatic. All of these ways, 5 ways, actually depend on evidence. All right, these 5 ways depend on evidence. So I hope it hasn't been such a heavy topic for you. I'll just do a recap. 5 ways you can prove that you are the owner of land. 1, through evidence of traditional history. 2, through production of title document duly authenticated. 3, by acts of ownership extending over a sufficient length of time, numerous and positive enough to warrant the inference that the person is the true owner. Number 4, through acts of long possession and enjoyment of the land. And number 5, by proof of possession of connected or adjacent land in circumstances which renders it probable that if you own this one, you would also own the other one. Now, if you have any comments or any questions, please leave it in the comment section and we'll respond to it. And if you like this video, please give us a thumbs up, subscribe and share it. Click the notification bell. If you don't like it, also give the thumbs down and let us have your comments. Thank you very much. See you in another video. 24 hours, 7 days a week.
For more exciting, educative and entertaining programs such as Law and You, Talk Politics, Entertainment Gist, Relationship Talk, and other programs, keep watching Pinnacle TV. subscribe to our YouTube channel at Pinnacle TV Online. You can also visit our website at www.pinnacletv.com. Follow us on Facebook at Pinnacle TV Online or call us on 081 546